We do have a couple people set up for the September.
Did I type it right? 10:19. Okay.
Cheryl, is that you? We can hear you. I don't know if that sounded like Cheryl. For the September to December timeframe, we have a couple speakers, but we are looking for more. So please email me at, oh my gosh, I'm drawing a blank. It's learn@pmiwic.org, I believe, if I have that right in my head, the right syntax on it. And then just let me know what month works for you. It's always the second Wednesday of the month. And as you know, we have July and August off. Let's see here. I'm just looking at my notes to see what else I've got on here. I think that's all my notes. So now I'm going to go ahead and introduce George Lewis, our speaker for today. George Lewis has managed technology projects since 1982, spanning disciplines as varied as NMOS process design and electron beam lithography, firmware for laser and inkjet printers, software solutions for commercial printing, patent portfolios valuation for a $1 billion acquisition, web applications, and is that IoT or LOT appliances? Wow, that shows how well versed in
it's IoT.
Yeah. Let's see, and he was introduced to GDPR, which is what we're going to talk about today, in 2017, and was tasked with preparing his company, who were developing and maintaining cloud software for worldwide customers for compliance. I will get rid of that background noise in just a second here. In his spare time, George is a youth soccer referee. Ah, that's fantastic.
Yep.
A PMI-WIC Director of Technology and a proud grandpa. I'd like to introduce George Lewis today. He's going to be our speaker.
Thanks, Jen.
Thank you.
Start up again here, and hopefully people will be able to enjoy the presentation. GDPR is an interesting topic, and one that is potentially really important and potentially just of interest. So as we go through these discussions, we'll hopefully come to a better understanding of what it's all about and whether you need to worry about it. So the again, topic today is GDPR and why should I worry about it? And I did want to start out with a disclaimer. We are talking about legal matters and laws, but I am not an attorney. So whatever I say should not be understood to be legal advice. It is just based on my experience. And if you do have specific questions for your organization that are important questions on what you should do, I would encourage you to find legal counsel to help you through that process. But hopefully it'll give you enough understanding through today's discussion to figure out when you need to do that, and be ready to follow up with somebody who is an attorney. I'd like to start with just a quick question for the group, and Keith will let you start with a poll just about what you know about GDPR already and how much you are worried about it. So as you start, looking at this, deciding just in your own mind, what's your level of knowledge about GDPR, and just to give me an indication of where the group is in terms of background and experience, and knowing what GDPR is. If you know what the acronym stands for, that would probably be a little bit.
And George, I forgot to mention that to let people know they can ask questions throughout the presentation, and we will be logging them and try to address them throughout the presentation.
Okay, yes, for sure. Since everybody is on mute, the way to get questions in would be to type it into your questions box. and we'll get those and try and respond as well as we can.
Well, there's a few people left that haven't voted. We're about 90%, so there's a couple. Give it a few more seconds.
All right.
But there's a definite trend.
I'll be interested to see that, yeah.
All right, last call for responses. Okay. Well, I'm going to close this and publish the responses so you can see. And
Oh, okay. So trending towards the low end of the scale. Good. Well, we'll have an interesting discussion and hopefully enlightening. For those that know more than most, feel free to correct me if I say something that is incorrect. And questions would probably be your best way to pop that through to us. Okay.
okay.
The next one on the level of interest.
On the worry level?
Yes, worry level. Go ahead and pop that one up. One of the things that I'm interested in, I'm not sure we'll be able to pull it from the information here, is whether or not knowing more about GDPR makes you more worried or knowing less about it makes you more worried. But we'll see what the general consensus is. I would say while we're waiting on this one, I'm not particularly surprised about knowledge on GDPR. We're in Idaho, kind of far from the European Union, and not everybody is going to have interaction with them. And so the transmitting of knowledge about it may be a bit slow at this point. On the other hand, there are businesses here that do manage worldwide services, and for those, knowledge of GDPR would be crucial as far as I know.
All right, well, we've almost to the same percentage as last time. There's maybe a couple people.
Okay.
A couple more seconds and we'll close this one. Put your vote in. Polls are closing. All right, well, we'll go with that. And
okay. Okay, so if I look at the distribution, it looks like there is more worry than experience in this one, which is fine. That's good. So for those of you that are not at all worried, listen carefully and we might change that a bit. Hopefully it'll be a productive worry that'll help you to drive towards a better product in the long run that would be compliant, and we'll talk about some of the reasons why. So, okay, thanks, Keith. Appreciate it. Let's continue on, and we'll talk a little bit about what GDPR is. And hopefully this will be informational for you. General Data Protection Regulation, and this is a law. It was passed by the Parliament in the European Union. Kind of the old standard for data protection was called Safe Harbor. This is a while back. that essentially said, you know, as long as you're treating the data as if it were your own, then you're probably okay. And things were pretty loose. And the EU decided that that was not sufficient. And they addressed a number of areas, one of which is to make sure that when personal data is collected, it is with the consent of the individual. And we'll talk more about that, whatever data is collected is protected in transit and in storage. And there are organizational processes involved also. It's not just a technical law. It's what your company has to do in order to show that you have the processes in place to follow the regulation. So governments are involved, companies are involved, and it spans quite a large range of functionality. 4 basic elements. Probably the top one is user control of data. And that really corresponds to the fact that the individual is the one who is considered to own their personal data. So even if you as a company temporarily have custody of this data, so somebody has entered their email address into your website, you don't get ownership of that. The individual still owns that, and they can ask for it back. And they can ask what you're doing with it and expect to get an answer. So that individual user data ownership is a key part of GDPR. So the handling of data is important. Number one, you have to justify any collection of personal information, and that has to be done in writing and be demonstrated that that is a justifiable and what they would call a lawful purpose. And if it doesn't fit that, then it's unlawful. And you can get in trouble for collecting data without justification. Some of the justification might be in order to provide the service that the person wants. That's fine. But the justification can't be just to say, oh, we're building up a marketing database and we'd like to collect everybody's information so we can mine it for information. Then it gets a little bit more problematic, but still can be done with the consent of the individual. There are some administrative requirements. Again, the company has to put in place some processes to ensure compliance, and the penalties, the maximums are outlined in the law. There are a number of remedies that the EU can impose if you are not in compliance. And probably the other area also is this increased scope over safe harbor. Best efforts no longer sufficient. And if you get called on the carpet for a breach of some kind or a violation of the law, just saying we did our best is not going to cut it anymore on that. So a lot of people have been concerned about how to get compliant. And this is one illustration of wishful thinking. And unfortunately, this one actually doesn't work. And you may find companies that are offering their services and say, you know, for a fee, we will certify you GDPR compliant. Be careful on those because there is no official certificate that can be issued. The compliance is up to each of the countries in the EU, whoever you are dealing with, and they're the ones that set the rules on that. Let's see. Just as a note, this slide's a little bit busy, but let me explain it. There are 99 articles in this law, and each article tends to run about a page or two. So we're looking at a law that spans 150, 200 pages. In purple, you will see where all of these various articles fit in the categories. And the categories are part of the regulation as well. So this is the EU's organization of all of these articles. And the blue lines are the ones where I had done a previous study for a company of the articles that I felt we needed to worry about. So there are some that you don't need to worry about. For example, Articles 60 to 76 on cooperation and consistency, those refer to the cooperation between European countries, because each country has its own organization to manage the process. How do you make sure that all 15, 20, 25 countries are doing things in a relatively consistent manner? So that section of articles deals with the country to country consistency mechanisms for how they try and stay in sync. And as a company, there's not a whole lot you can do there on that. Specific processing situations, Article 85 to 91, deal with things like special exemptions for law enforcement and other special cases that we didn't have to worry about. But of the other articles, there were a number that in total, I think we ended up with about 30 articles that would require some action from our company. That we were involved in a worldwide website that collected personal information from users to provide a service to them. And again, not all the articles applied, but 30 was a pretty big number that we had to deal with. So who does the law apply to? It's pointed towards residents of the EU. So if, for example, you have a French national person working in your company in the United States, and they have to give their data to the HR department, they are not located in Europe, and so GDPR would not technically apply to the data that they supply to HR. On the other hand, if they're working in France and working remotely, and they need to give their bank information so that they can get paid, then GDPR all of a sudden kicks in. You're handling personal data of an EU resident. Again, the residents, the organizations that handle their information, and organizations that manage data on behalf of other organizations that have data on EU residents are also covered. And this is true even if your organization or company has no physical presence. So it's an interesting law that the European Union has passed a law that affects people that are not in the EU. And so as long as you're handling personal information, and again, remember the individual owns their information, so you have custody of it, you are under GDPR. So here's your big question. I don't do business in the EU. Why do I need to worry about it? Again, as I mentioned, you have the worldwide reach. The penalties are pretty steep. And so if there's any question at all, it's worth double, triple, quadruple checking to make sure that either and being aware. Okay, another poll. When did GDPR become law? And Keith, I'll let you pop that one out and let people vote on that. Anywhere between 1998 and 2019. See what the thinking is. It's interesting to think about what happens in parts of the world that you don't normally have to worry about, and things can happen and take their course, and then when you find out about it, it's like, oh, that's an interesting twist on things that can affect the business. You should have had one choice on here that said, you know, I have no idea. But pick one and we'll go with it.
All right, you left to vote.
Okay.
Couple more seconds. Okay, we'll close this down. And
Okay, 8%, 19, 51, and 22. Interesting. So, all right, there is a right answer on this one. And we'll pop that up here. And we'll talk about it because the responses from this group are not unusual. 1998 was when safe haven became effective. And that was, as I mentioned, the understanding. It wasn't really a law. Understanding that data protection was important. It was more a best effort kind of thing. GDPR became law in 2016. The interesting thing was that at that time, when it became law, enforcement was delayed or postponed. That was deliberate because they were building in a grace period of 2 years. And in May of 2018, the enforcement of the law started. Now, from my experience, most people didn't even notice that the law went into effect in 2016. They only noticed in 2018 that the enforcement was coming up. And so a lot of people do understand that 2018 was the start of GDPR, but I was involved in 2017 in getting ready for the start of the enforcement. And I know that a lot of people were starting to communicate with the EU saying, can we have a grace period? You know, we're still working away to get compliant. And the general response at the time was, we've given you 2 years of grace period already. You know, what have you done with it? And the fact that nobody paid attention was not considered a good enough excuse. And so there was a lot of scrambling around May of 2018. For those of you that chose 2019, the most important thing I could find in August of 2019 was the 60th annual finger wrestling championship. I think that was held in Germany. But that was just a date I picked to make another interesting date in the list. But we're sitting in 2020 now, 2 years after the enforcement has begun. And so arguments about a grace period are not going to fly anymore. But yeah, 2016 was the actual start. Okay, 2 parts, as I've mentioned already. One dealing with the organization. And again, this is a law that your organization is expected to comply with. And one is about handling the data. And on the organization side, you get to justify the collection of any and all personal information. And one of the first things in a checklist would be, are we collecting information that we don't really need? You know, just because it was a normal part of our process before. You have to go through, and for every piece of personal information, there has to be a justification. Why do you need that? And it's for your own protection as well, because if you don't need it, you're still on the hook for taking care of it. Yeah, so you might as well cut the list down to just the data that you really need to run the business. You have to keep records of all your transactions and keep records of what data you have stored. And as I'll mention later, there's no grandfathering. So if you have data stored already of European residents, that data storage is considered part of what GDPR would be covering. They didn't say that you know, anything you've done before can be automatically forgiven. And so one of our efforts was to go back and look at all of the stored archive databases to see if they needed to be either purged or edited to remove any unjustified personal information. The organization has to have a link to the regulators in the EU. And I'll talk in a minute about the details on that, but you essentially have to pick a country. Each country has its own organization to administer GDPR, a European country. And the country you pick might be the one that you do the most business in. It might be the one that you have a remote office in. If you use something like Amazon Web Services, you know, they have a big data center in Ireland, so you might pick Ireland because that's where the data is being stored. But you have to pick one country and create a nice, strong link between your company, organization, and data protection and the regulators in that country. And you have to be able to demonstrate compliance. Now, I talk about this unbroken chain of contracts. If a country is considered to be basically compliant, which means that their data protection laws are just as strict as the ones in the EU, then you don't necessarily need contracts. But the United States is not considered a secure country, and so they expect you to sign up with the EU by contract saying we will abide by GDPR and we will accept the penalties if they are given. And that is because we're in a non-compliant country and don't have the protections by law built in here. On the data side, bunch of protection for the databases. The opt-in language has to be clear and understandable. I've got some fun examples of what it means to be clear and understandable. And there's some special screening for minor children because ownership of personal data for minor children is considered a big deal. And there's some extra provisions on that. So here's kind of a diagram of what I've been talking about. Within the EU, each country has its own organization. It's called a supervisory authority. And the country decides whether it's, you know, a new cabinet level ministry or it is a department under the cabinet level area, the Department of Information, or however they do it. There is an authority identified, a bureaucracy put in place to manage GDPR. Companies will be classified as either a controller or a processor. And with that, we'll talk more about that as well. The controller is expected to have that direct link to the supervisory authority. And you'll see here on this slide that says that there's a DPO, Data Protection Officer. And that's one person who is in direct contact with the supervisory authority. Technically, that person should be located in the country that the supervisory authority is located in and speak that language, whatever it is. So if your choice of country is Germany, your data protection officer would be living in Germany and speak German and be answerable to the supervisory authority. And there are some pretty unique regulations about that data protection officer. They have to be kind of like an ombudsman who who cannot be fired for doing his job and really works at the C level of an organization. Not all companies need a DPO. In fact, you can be a fairly large company, and that function can be something that you contract with a broker who is located in the country to be your data protection officer. That's probably the more normal way to go. Processors kind of work for the controller. The controller manages what data is being collected, how it's handled, the justifications, and what is done with the data. The processors may work on the behalf of the controller, but they are part of the equation. And again, if they are located in a country that is non-compliant, you're expected to have contracts between controllers and processors that basically say you will abide by GDPR and you will handle data in the way that we have outlined for you. This is an interesting situation because in a lot of the experience that I have in company-to-company dealings, it's a little bit more, I say, undefined. It's not a hierarchy. So even if you get hired, you're a software company, you get hired to do a website. It may be that the controller company says, hey, you just handle everything and tell us if there's a problem. Okay. So the processor might be handling all the data. The controller never really sees it. There's still a controller. And the definition is in the law of what a controller really is. So for both controllers and processors, here's what you need to have. Again, subject to the supervisory authority. The US is not compliant, not adequate for data protection. There's record keeping and audits, and there's the requirement to notify the supervisory authority of any breach of personal information. And in most cases, that is within 72 hours. So you notice a breach, you've got 3 days maximum to notify the government that there has been a breach, and they will most likely want to have more information about that. And they'll want to see your audits and to see your practices, to see whether or not you have been implementing the requirements of GDPR. And if not, then they start deciding, all right, what are we going to do about that? And go from there. But the organizational requirements are as important as the data requirements. So question, who's a controller? If you choose the data, create the means of collection, interact with the data subjects. For example, if the website that they're logging into has your brand on it, then you're a controller by law. You don't get to say, well, we don't think of ourselves as a controller. That's not the way it works. The people that claim to be processors and are really controllers kind of start out with one strike against them in any process with a supervisory authority. So they like somebody to step up and say, yeah, I'm responsible, and we'll make sure that this product complies. There are other factors that are not part of determining who a controller is, and so a processor can do a whole bunch of stuff and still not be a controller. But the controller has extra responsibility. If there are any fines levied, they are levied against the controller. And so it's not necessarily a comfortable position to be in. And this is one of the ways in which you can think of that the controller is the one who's responsible to the supervisory authority. And beyond that, if a processor has created a breach or a problem, the controller, having a contract with the processor, can then go after the processor to recover, damages or whatever from the processor. But that's between the controller and processor. That's not between the government. and the processor. On the data side, okay, we've gone through the administrative side. On the data side, we talked about the justification. In most cases, that means that the person who is giving the personal information has to opt in consciously, and they have to understand what they're agreeing to. And so they say, well, gee, I would like your service, therefore, I will give you this information so you can provide the service. And this is the part that most people think about when they think about GDPR. Privacy statements, part of the justification that is public to the user. And I don't know if you've seen a lot of new privacy statements coming out. I know in the last year, it just seems like every week or so, there are a bunch more new privacy statements and updates. And even on your phone, a lot of the updates that you'll get on the apps are to put in an updated privacy statement. A good part of that is driven by GDPR and the need to be compliant with GDPR. A couple other things that may be new that you haven't had to do in the past. One is if somebody asks, you've had a subscriber for a couple of years and they write you a note saying, what data have you collected on me? And it might be, phone number, email, subscription history, whatever else that might have been collected over time. You have to provide that back to the user. You have to be able to respond and say, okay, here's the data that we have about you. This is important, for example, if you're a credit agency and you're collecting credit card information for European residents. They can ask and say, all right, what information do you have about me? And you have to provide that. If the person says, I would like you to forget me, take me off your list, I no longer want your service, and I don't want my data hanging around in your database, you have to comply with that. And you have to be able to show that and show an auditor that you are complying with those requests. And they say it has to be as easy as opting in. And historically, getting out of a subscription is a lot harder than getting in. And I know I have a recent experience with a statesman on that. But the process of opting out is expected to be as easy as opting in. If you have a system that has personal information and a bunch of other historical data, that person is supposed to be able to request that from you in a form that they could take to another provider and say, I would like to discontinue your service, but I'd like to start it up with somebody else. Please give me everything you have on me in a form that I can take to somebody else. Again, auditable. And data transfers, which was a big part of Safe Harbor. But if you're going to a non-secure country, the data transfers have to meet the GDPR security rules of encryption in transit and in storage. And you have to be able to show that your product that is doing the transmitting has security built in at a fundamental level on that. I mentioned extra protection for children and regular audits. So again, this is kind of the meat and potatoes of what most people think of for GDPR. And another example of how that can be implemented in real situations. And it's in GDPR land, it's a fair question. Okay. All right, on to privacy statements. We talked about they have to be understood, they have to be accessible, get rid of all the legalese, and there has to be an informed choice. And here's an example. This is from Google. And if you read through that fairly quickly, you'll see that that's plain language. That is not lawyer speak. This is intended for somebody who is not an attorney to be able to understand it and know exactly what's going on. And Google, of course, is in the crosshairs of the EU. Number one, the EU distrusts any big company. Google is one of the biggest. And their usage of data is legendary. And in fact, if you dig down deeper in the privacy statement, you'll see another phrase. This is just one that I picked up on. and it's having me rethink a little bit my use of Gmail, which is kind of my personal mail, has been for years. But they collect not only the stuff in Gmail, but they collect the emails that you receive from everybody else, photos and videos, documents and spreadsheets that you create, and comments you make on YouTube. And in the past, all of this would probably have still been in their privacy statement, but buried in some legal terminology that would have made it hard to pick out what's going on. In the new requirement for clear language, it kind of jumps out. And so that's what Google is having to do in order to be compliant. Here's one from Facebook, another big company. And again, different organization, but well organized and a little bit more customer focused in terms of just a question. And you can click on each of the various topics if you're wondering what their privacy statement says about these various areas. And you'll notice at the top, they also show the California Consumer Privacy Act is effective as of January 1st. You can learn more about your privacy rights here. So if you are providing a service for people in California, you might want to be aware of what rights they have about their data. Again, it's not the same as GDPR, but some of the principles are the same and worth going to check out. Here's a little quiz for you. Here's another privacy statement, fairly clear language, perhaps not as clear as Google's, but this is not a poll. I'm not going to solicit answers, but as you read through this, try and figure out, if you can, who might be implementing this kind of privacy statement. Give you a minute to read through it, formulate an opinion. That's from the state of Idaho website. So again, even though we're here in Idaho, far from the EU, you'll see that some of the elements that we've talked about are creeping into privacy statements. And this is one of the ways in which GDPR becomes important to know about, because it's not just in the EU, it's becoming more widespread. People expect to get this kind of clear information in a privacy statement now that it has become more common. Okay. Let's see. Data handling and protection of data from disclosure. We talked about this one already. Privacy by design and default. That's a term that's in the law, is that if you find yourself in a situation where you need to answer to an authority, they will want to see, all right, what have you done to ensure that your product is designed for data protection from the ground up? And how have you implemented it? And according to the law, those are fair questions that they can ask, and may have a bearing on how strict they are with you. If you can show that you've tried your best to design this thing from the ground up as a secure system, then you may get a little bit more favorable treatment at the hands of the supervisory authority. Okay, let me jump to what people have been talking about for a long time on GDPR, penalties for non-compliance. And there are really two buckets that this fits into. There is a group of issues that fall into a less severe category. Those are the ones on the left in blue. And there are some that are considered more severe that fall into the list on the right. And on the left, it can be just as much, if you are gathering information from children without their consent or without consent of their legal guardian, that can be a problem. It's a violation of GDPR. If you haven't kept proper records, as I say, this will work against you. And if you have a breach that is not passed along and not notifying the supervisory authority, that can be a problem as well. The remedies or the penalties that can be imposed range everywhere from a warning, which is probably the most likely, unless it's a severe breach. But they can also go as far as suspending your company operations in Europe or in that country. Again, it's up to the supervisory authority. So they can just close you down as part of GDPR. And things like this get people's attention, that all of a sudden I would lose all my sales in a country, or I would lose my ability to be a universal solution for everybody. But the fines also get a lot of publicity. So the fine for stuff down the left side can be up to 10 million euros, or 2% of your company revenue for a year, whichever one is greater. So if you're a small company and you're making, $500,000 a year or $1 million a year, and you run afoul of this law, you could get fined up to 10 million euros, which would hurt. That would not be recoverable. Again, it's a range. It's up to the supervisory authority what they feel is appropriate for the severity of the breach. Or if you're a large company and your revenue is in the billions, and 2% of that annual revenue is still going to hurt, because your profit margins might be in the range of 5 or 6% after taxes, and all of a sudden you lose a third of your profits for that year if you got a maximum fine on doing that. So that's why people got really excited about 2018. All of a sudden, there were some very big teeth in the regulation, and it was going to be enforceable by law. On the right side, there's some more serious things that are considered more serious. And again, failure to obtain explicit consent for collection and processing is probably the most obvious, that you now have to ask somebody for permission to use their data. And you say, please opt in. And you'll see a lot more checkboxes on websites now saying, yes, I agree that you may use my data to provide your service. The non-compliance with an order by supervisory authority. So if you get a warning and don't do anything about it, you kind of shift over to the right side. And transmitting data without protections to the US can get you in that right side on that, because we're considered an unprotected country. And in this case, the fines can be double. So 20 million euros or 4% of your annual revenue. And I think even Google would notice that. So, and again, whichever is greater. Now the penalties are imposed on the controller, which is why it's so important to have that company identified. And so the annual revenue number would be the annual revenue of the controller. And it's not unusual to have one controller and a bunch of processors. So the controller gets the fine, and then they look at their processors and say, all right, who screwed up here? And if there was a breach by one of the processors, then the controller will try and pass that fine along to the processor by saying, hey, we did what we needed to, but you screwed up, so you get to pay this fine. And as far as the EU is concerned, they fine the controller, and that's their one neck to choke. And then it's up to the controller to figure out, who really is at fault, and based on the contracts that are in place between the companies, how do we recover what is, what has been given as a fine. So the net result is never to get to this page. That's the easiest. The best defense for all of this is to be compliant. So for example, if there is a breach, and you can show that controllers and processors have all been compliant and done their, due diligence in putting the processes and protections in place, and there was still, an unforeseen problem, then you might end up with, a warning: do better, fix your processes, let's not have this happen again. But again, it's up to the supervisory authority in the country that you're doing business with. But typically, the best defense is compliance on that. And so, in that vein, the safest strategy is, clean up your privacy statements, make them in plain English or plain whatever language. Really be careful about justifying all the data that is being collected. And again, if you're not under the umbrella of the European Union or GDPR today, these are becoming good practices for everybody, because at some point you might expand. At some point, Idaho might pass a data protection law. It will probably be modeled on the standards that are in place at the time, which would be GDPR. So you can start working on making sure that the data that you collect really is necessary. Work to make sure that your product has security built in, and make sure that you're compliant all the way through with the various processes. All right. So, a couple of polls here. Curious to know what your thoughts are. Which PMI knowledge areas are going to be affected in your projects by what GDPR is and does and could do? Where do you see the effects coming in for your projects? Now, the polls in this webinar are limited to 5 responses. So we split it into 2 parts. But what I'm asking is that you check all that apply. And so we're not going to lose any information by doing this in 2 pieces. So if you think that GDPR is going to affect your project in these areas, in one or more of these areas, please check the boxes, and we'll collect that information. And Keith, if it's possible, can you show the second poll before you show the results of the first one?
Yes.
Okay, so we'll collect all 10, and then we'll go back and show them.
Yeah, we're at about. All right, a few more seconds on this first poll.
Okay.
About 86%, so that's pretty good. Okay, we'll go to the second one. Yeah. And it's, all right, there we go.
Okay.
Get results coming in. All right, a few more seconds.
Okay. I'm interested to see what people have to say here.
Okay, we'll close down this one here and go back to the first one and show the results.
Okay. So scope was the winner in this batch of 5, and schedule and quality not so much. Cost could be affected, integration could be affected. Okay, interesting. Yeah, I would tend to think schedule might come into play as kind of tracks with scope, but yeah, by itself, if you're doing things in line, scope probably takes precedence. So, okay, good. Thank you.
Okay.
Source risk management. Okay, I have to admit, risk management is my favorite. So it's gratifying to see 97% saying, "Yep, that's that is an area to highlight," especially in the early days. That's as you're getting started with GDPR. Not everybody in the organization is going to be aware of what the needs are, and communications, stakeholders. Good, yeah. Procurement, I tend to agree where that is, but also realize that if part of your procurement is in collecting subcontractors or people who are potential processors, then you might have some extra contract requirements to bring them in as part of your procurement process. So if it's procurement for hardware, not so much. If it's procurement for modules that affect data, definitely it could have an effect. So, okay, great. Thank you. All right. Let's come back and take a minute and look at a quick case study here. And I've alluded to it a couple of times in some of my other examples. Let's say we have two companies, A and B, and company A is a big company that has products that are sold worldwide, that a well-known brand presence, lots of product lines, and they decide that on one of their product lines they'd like to provide a website for some additional services. And not necessarily a product, but something to help people use their product. And because they're a big company and they have big company budget constraints, and they don't want to hire a bunch of people to go do this, they contract with company B and basically say, "Hey, would you do this website for us? Design it, build it, manage it, and just tell us how things are going." And